Extinguishment of Obligations General Provisions Art 1231. Obligations are extinguished 1. By payment or performance. 2. By the loss of the thing due. 3. By the condonation or omission of the debt. 4. By the confusion or merger of the rights of creditor and debtor. 5. By compensation. 6. By novation. Other causes of extinguishment of obligations, such as annulment, rescission, fulfillment of a resolutory condition, and prescription, are governed elsewhere in this code. Note: extinguishment of obligations regarding death. General rule: death does not extinguish an obligation. Exception: it extinguishes the obligation if such obligation is personal in nature or intransmissible. General rule: where civil liability does not exist independently of the criminal responsibility. The extinction of the latter by death ipso facto extinguishes the former, provided that death supervenes before final judgment. Exception: if the civil liability neither solely nor originally springs from the crime, the civil liability shall persist despite the extinction of the criminal liability. I payment or performance Art 1232. Payment means not only the delivery of money but also the performance, in any other manner, of an obligation. Note: there are two prestations involved in payment. 1. To give delivery of money, and 2. To do performance of an obligation. Payment is done both by the creditor and debtor in reciprocal obligations. The law expressly declares that in obligations to give, what is required is the delivery of money, and not cash, check, etc. Art 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Art 1234. If the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Art 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or objection, the obligation is deemed fully complied with. Fulfillment of payment. Note: an obligation is deemed fulfilled when the obligation has been completely delivered or rendered, including the delivery of all the accessories of a determinate thing in an obligation to give. Anything less than a complete performance may be considered a breach in obligation. There are two exceptions to this rule. 1. Substantial compliance and good faith. For this to apply, the part unperformed must not destroy the value or purpose of the contract. The breach in obligation is not a material one enough to compel the obligor to rescind the obligation. The debtor can pay less damages suffered by the obligee too. Waiver of obligee of incomplete or irregular performance. By not expressing any protest or objection, the obligee accepts the performance of the obligation as fully complied with despite his or her knowledge of such irregularity or incompleteness. If there is a protest, the law does not require such to be made in any particular manner or time. Art 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except that if he paid without the knowledge or against the will of the debtor, he can recover only insofar as the payment has been beneficial to the debtor. Art 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the latter, cannot compel the creditor to subrogate him in his rights, such as those arising from a mortgage, guarantee, or penalty. Art 1238. Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent. But the payment is in any case valid as to the creditor who has accepted it. Payment by third-party debtor. Note: whether or not one who paid completely acquires the rights of the creditor depends on whether or not the payment has been made without the knowledge or against the will of the debtor. 5 situations may arise. If the third party pays: 1. Without the knowledge or against the will of the debtor, third person who paid can recover only to the extent the debtor has benefited. This is to be invoked by the debtor, and the extent is to be decided by law. The beneficial effects must be determined at the time the payment was made to. With the knowledge but against the will of the debtor, same as 1. 3. With the knowledge and consent of the debtor, there is legal subrogation which transfers to the person subrogated the credit with all the rights thereto appertaining. Third person can recover from the debtor the amount paid to the creditor, as well as compel the creditor to transfer to him or her any mortgage, guarantee or penalty for, because it is allowed in contract, same as 3. 5. Without the intention to be reimbursed by the debtor, obligation is extinguished whether or not the consent of the debtor is obtained. The payment will be treated as a donation. Art 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due and capacity to alienate it shall not be valid, without prejudice to the provisions of Article 1427 under the title on Natural Obligations. Art 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Art 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit to the creditor need not be proved in the following cases. 1. If after the payment, the third person acquires the creditor's rights. 2. If the creditor ratifies the payment to the third person. 3. If by the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment. Art 1242. Payment made in good faith to any person in possession of the credit shall release the debtor. Art 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. Notes: valid payments. 1. Payment made to a. the person in whose favor the obligation has been constituted, b. the successors in interest, c. any person authorized to receive it. Such person must be authorized by the creditor and the law. Note: payment made by the debtor to a third person, even though in error and good faith, shall not release the debtor from the obligation and will not deprive the creditor the right to demand payment, except if the payment redounded to the benefit of the creditor. General rule: if the payment redounded to the benefit of the creditor, such benefit needs to be proven. Exception: such benefit does not need to be proven. A. If the third person acquires the creditor's rights after payment. B. If the creditor ratifies the payment. C. If the creditor's conduct has led the debtor to believe that the third person had authority to receive payment. 2. Payment made to a person incapacitated to administer his or her property, if a. the incapable person has kept the thing delivered. B. or, insofar as the payment has been beneficial to him her. Note: payment to the incapacitated is often disadvantageous for the capacitated party, because the capacitated person party cannot annul the contract on the basis of the incapacity of the other person. If the contract is annulled, the capacitated person cannot compel the incapacitated person to make a restitution, except only to the extent the latter has been benefited. 3. Payment made in good faith to the person in possession of the credit, whether the creditor negligently, intentionally, or accidentally allowed a third person to possess the credit as a material as far as the debtor who paid in good faith is concerned. Notes: invalid payment. 1. Payment made by a person without free disposal of a thing. Note: a person has free disposal of a thing when he/she owns it or has been given authority by the owner to use the property as payment. Any contract entered into by a minor with respect to the alienation of something is annullable too. Payment to a third person, even though in error and in good faith, when no benefit redounded to the creditor. 3. Payment made after the debtor has been judicially ordered to retain the debt. Usually this order is made to protect other creditors. Art 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as, or more valuable than that which is due. In obligations to do or not to do, an act or forbearance cannot be substituted by another act or forbearance against the obligee's will. Art 1245. Datation in payment, whereby property is alienated to the creditor in satisfaction of a debt in money, shall be governed by the law of sales. Art 1246. When the obligation consists in the delivery of an indeterminate or generic thing, whose quality and circumstances have not been stated, the creditor cannot demand a thing of superior quality. Neither can the debtor deliver a thing of inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration. Art 1247. Unless it is otherwise stipulated, the extrajudicial expenses required by the payment shall be for the account of the debtor. With regard to judicial costs, the rules of court shall govern. Art 1248. Unless there is an express stipulation to that effect, the creditor cannot be compelled partially to receive the prestations in which the obligation consists. Neither may the debtor be required to make partial payments. However, when the debt is in part liquidated and in part unliquidated, the creditor may demand and the debtor may effect the payment of the former without waiting for the liquidation of the latter. Art 1249. The payment of debts in money shall be made in the currency stipulated, and if it is not possible to deliver such currency, then in the currency which is legal tender in the Philippines. The delivery of promissory notes payable to order, or bills of exchange or other mercantile documents shall produce the effect of payment only when they have been cashed, or when through the fault of the creditor they have been impaired. In the meantime, the action derived from the original obligation shall be held in the abeyance. Art 1250. In case an extraordinary inflation or deflation of the currency stipulated should supervene, the value of the currency at the time of the establishment of the obligation shall be the basis of payment, unless there is an agreement to the contrary. Notes: Modes of payment. General rule: the debtor has no choice in the payment of the obligation other than what has been agreed upon by the parties, exception, unless the prestation is subject to a facultative or alternative condition. Datation in payment, also datation on pago. This is the delivery and transmission of ownership of a thing by the debtor or creditor as an accepted equivalent of the performance of an obligation. Requisites: a animo solvendi, or the performance of the prestation in lieu of payment, which may consist in the delivery of the corporeal thing, real right, or a credit against the third person, be aliud pro alio, or a difference between the prestation and what is given in substitution. See an agreement between the creditor and the debtor that the obligation is immediately extinguished by reason of the performance of a prestation different from that due. Agreement may be express or implied, or even silent. It is important that both parties consider the substitute thing as equivalent to the obligation. How does one judge the intention of the parties to agree in a datation on pago? Their contemporaneous and subsequent acts shall be considered. Notes: 1. dation on pago, before the creditor becomes the owner of the collateral property. An intervening agreement subsequent and independent from the original contract is entered into by the creditor and the debtor to have the property collateralized as payment, thereby extinguishing the obligation, valid. Because the appropriation of the property is not automatic, as compared to a pactum commissorium. 2. Pactum commissorium. The parties agree, generally in one single contract, that in the event the debtor fails to pay, the mortgaged or pledged property of the debtor shall be automatically appropriated or owned by the debtor, void. Because as a rule, properties mortgaged should be subject to a foreclosure sale first if the property shall be used to satisfy a debt. Notes: payment of an indeterminate thing. If the quality has not been stated, the delivery of the indeterminate thing shall neither be of superior or inferior quality. The quality shall be determined instead through the purpose of the obligation and other circumstances, e.g., financial. Partial payments. General rule: creditor cannot be compelled to receive partial payments, nor the debtor required to make partial payments. Exceptions: A. Unless there is an express stipulation to that effect. B. When the debt is part liquidated and part unliquidated. The creditor may demand and the debtor may effect the payment without waiting for the liquidation of the unliquidated part of the debt. C. Even if there is no express stipulation, if the creditor accepts the partial payment and benefits from it. Payment of debts in money shall be made in the currency stipulated, and if it is not possible, the currency which is legal tender in the Philippines, in the fulfillment of an obligation by payment by money. Only payment in cash will extinguish the obligation. Payment of debts in other forms, promissory notes payable to order, bills of exchange, or other mercantile documents shall be produced the effect of payment only when uncashed, or when through the fault of the creditor they have been impaired. A promissory note, a document where an unconditional promise to pay on a fixed or determinable future time is made by the debtor to the creditor. B. Bill of exchange, an unconditional order in writing addressed by one person to the other, signed by the person giving it, requiring the person to whom it is addressed to pay on demand or at a fixed or determinable future time a sum of money to the bearer. See check, a bill of exchange drawn on a bank payable on demand. In Far East Bank and Trust Company v. Diaz Realty Incorporated, the court said that if payment by way of a fully funded check were offered or tendered and the obligee accepts the payment after the obligor's manifestation that it had been given to settle an obligation, such obligor shall be stopped from denouncing the efficacy of such tender of payment. Delays in check encashment. Normally a check has to be deposited 6 months from the date indicated. If the creditor delays, the drawer of the check shall be discharged from liability to the extent of the loss caused by delay. Note how the drawer will only be discharged from a certain amount of liability. The drawer's obligation is not extinguished by mere delay of the creditor. It is only when the creditor does not present the check for payment and thereafter the bank collapses that it cannot meet the demands for payment, that the drawer of the check shall be discharged. In case of extraordinary inflation or deflation of currency. General rule: the value of the currency at the time of the establishment of the obligation shall be the basis of payment. Exception: unless there is a stipulation to the contrary, extraordinary inflation exists when there is an increase or decrease in the purchasing power of the Philippine currency which is unusual or beyond the common fluctuation in the value of said currency, and such decrease or increase could not have been reasonably foreseen. Effects of such inflation should be officially declared by competent authorities, such as the Banco Central or the Department of Finance. Only applies to obligations arising from contracts, and not those arising from law. Extrajudicial expenses for performance of payment. General rule: these expenses shall be shouldered by the debtor. Regarding judicial costs, the rules of court shall govern. Exception: unless there is a stipulation to the contrary. Art 1251. Payment shall be made in the place designated in the obligation, there being no express stipulation, and if the undertaking is to deliver a determinate thing, the payment shall be made wherever the thing might be at the moment the obligation was constituted. In any other case, the place of payment shall be the domicile of the debtor. If the debtor changes his domicile in bad faith or after he has incurred in delay, the additional expenses shall be borne by him. These provisions are without prejudice to venue under the rules of court. Venue of payment. General rule. Payment shall be made in the place designated in the obligation. Exception. If there is no express stipulation, and if the thing is determinate, payment shall be made wherever the thing might be when the obligation was established. In all other cases, payment shall be made at the domicile of the debtor. If the debtor changes domicile in bad faith, or after he/she has incurred in delay, additional expenses shall be borne by the debtor. A application of payments. Art 1252. He who has various debts of the same kind in favor of one and the same creditor, may declare at the time of making the payment, to which of them the same must be applied. Unless the parties so stipulate, or when the application of payment is made by the party for whose benefit the term has been constituted, application shall not be made as to debts which are not yet due. If the debtor accepts from the creditor a receipt in which an application of the payment is made, the former cannot complain of the same, unless there is a cause for invalidating the contract. Art 1253. If the debt produces interest, payment of the principal shall not be deemed to have been made until the interests have been covered. Art 1254. When the payment cannot be applied in accordance with the preceding rules, or if application cannot be inferred from other circumstances, the debt which is most onerous to the debtor, among those due, shall be deemed to have been satisfied. If the debts due are of the same nature and burden, the payment shall be applied to all of them proportionately. Notes. 1. Payment of multiple debts. A debtor with multiple debts may declare at the time of making one payment to which debt must such payment apply. The general rules of payment already discussed, Art 1232 to 1251, still apply here. However, if the payments cannot be applied in accordance with Art 1252 and 1253, or if the application cannot be inferred from other circumstances, then the debt which is most onerous to the debtor shall be deemed to have been satisfied. If the debts are all of the same nature, then the payment shall be applied to them proportionately. The most onerous debt is the debt which exacts the heaviest burden from among many. General rule. Application shall not be made to debts which are not yet due. Exceptions. A. Unless the parties so stipulate. B. Or when the application for payment is made by the party for whose benefit the term has been constituted. General rule. If the debtor accepts a receipt in which an application of payment is made, the debtor cannot complain. The debtor must not merely receive the receipt, but accept it. Basis. Doctrine of estoppel. Exceptions. Unless there is a cause for invalidating the contract, like fraud or intimidation. These are causes for annulling the contract. 2. Debts with interest. The presumption is that the payment of the principal, notwithstanding any remaining interest, supposes that such interest has been paid. Thus, the rule is if the interests have not been covered yet, the principal has not been paid as well. However, this is merely directory, and is rebuttable with sufficient evidence as such. The right to apply payment first to the interest can also be waived by the creditor. B. Payment by cession. Art 1255. The debtor may cede or assign his property to his creditors in payment of his debts. This cession, unless there is stipulation to the contrary, shall only release the debtor from responsibility for the net proceeds of the thing assigned. The agreements which, on the effect of the cession, are made between the debtor and his creditors shall be governed by special laws. Note: payment by cession is another mode of extinguishing a debt. Cession under this article presupposes financial difficulties on the part of the debtor, and refers to a situation where the debtor owes two or more creditors. It refers not only to the cession of a debtor of his or her property, but property that is not exempted from being alienated, valid only if the creditors agree to the cession. See Tender of Payment and Consignation, Art 1256. If the creditor to whom tender of payment has been made refuses without just cause to accept it, the debtor shall be released from responsibility by the consignation of the thing or sum due. Consignation alone shall produce the same effect in the following cases: 1. When the creditor is absent or unknown, or does not appear at the place of payment. 2. When he is incapacitated to receive the payment at the time it is due. 3. When, without just cause, he refuses to give a receipt. 4. When two or more persons claim the same right to collect. 5. When the title of the obligation has been lost. Art 1257. In order that the consignation of the thing due may release the obligor, it must first be announced to the persons interested in the fulfillment of the obligation. The consignation shall be ineffectual if it is not made strictly in consonance with the provisions which regulate payment. Art 1258. Consignation shall be made by depositing the things due at the disposal of judicial authority, before whom the tender of payment shall be proved, in a proper case, and the announcement of the consignation in other cases. The consignation having been made, the interested parties shall also be notified thereof. Art 1259. The expenses of consignation, when properly made, shall be charged against the creditor. Art 1260. Once the consignation has been duly made, the debtor may ask the judge to order the cancellation of the obligation. Before the creditor has accepted the consignation, or before a judicial declaration that the consignation has been properly made, the debtor may withdraw the thing or the sum deposited, allowing the obligation to remain in force. Art 1261. If, the consignation having been made, the creditor should authorize the debtor to withdraw the same, he shall lose every preference which he may have over the thing. The co-debtors, guarantors and sureties shall be released. Notes: 1. In case of creditor's unreasonable refusal to accept payment, general rule, the debtor has to make a tender of payment, and then consign the thing to the judicial authorities. Exceptions: consignation alone is enough when a. The creditor is absent or unknown, or does not appear at the place of payment. B. That the creditor is incapacitated to receive payment at the time it is due. C. That without just cause, the creditor refuses to give a receipt. D. Two or more persons claim the same right to collect. E. The title of the obligation has been lost. Expenses of a proper consignation shall be charged to the creditor, because it is the creditor's failure to accept payment which led to the consignation. 2. Effects of consignation. Once consignation has been made, the debtor may ask the judge to order the cancellation of the obligation. The consignation is retroactive, such that the payment is deemed to have been made at the time of the deposit of the money in court, or when it was placed in the disposal of the judicial authorities, before creditor has accepted the consignation or before the judicial declaration of consignation has been made. However, the debtor can still withdraw the thing or the sum deposited, allowing the obligation to remain in force prior to the withdrawal of the debtor of the amount. The creditor may accept the amount consigned either conditionally or with reservation if the creditor authorizes the debtor to withdraw the amount after consignation. the obligation is revived, but the creditor shall lose preference to the thing previously deposited to pay his/her debt. Solidary creditors also lose the preference, since the creditor cannot revive the obligation without their consent. This means that any other person who has an interest in the payment can go after it. Notes: Tender of payment versus consignation. 1. Tender of payment is an offer of payment antecedent to the consignation. It may be extrajudicial. It is necessary that there be a fusion of intent, ability, and capability to make good such offer, which must be absolute and must cover the amount due, be that the tender be made in lawful currency. 2. Consignation is the act of depositing the thing due with the court or judicial authorities whenever the creditor cannot accept or refuses to accept payment, and it generally requires a prior tender of payment. 3. Both apply in any contract where there is an obligation to pay. Notes: Requisites for a consignation to be effectual. 1. That there was a debt due. 2. The consignation of the obligation had been made because the creditor to whom tender of payment has been made refused to accept it, or was incapacitated or absent, or because several persons claimed to be entitled to receive the amount due. 3. The previous notice of the consignation has been given to the person interested in the performance of the obligation. 4. The amount has been placed in the disposal of the court. 5. After the consignation is made, the person interested was notified thereof. The purpose of the notice is to give the creditor the opportunity to reconsider his/her unjustified refusal and accept payment, thereby avoiding consignation and subsequent litigation. The circumstances of the case and the order of the court granting the motion can be considered substantial compliance with the requirement of notice to the creditor.